Hello and welcome. It's Monday, the 11th of August 2025. My name is Malcolm Neekirk, and I'm joined by my colleague from my employment law team, Chris Dobbs, for this morning's session. Chris, good morning.
Good morning, Malcolm. Good morning, everyone.
Today we're going to be talking about reporting to the Redundancy Payments Service. Before I start the presentation proper, there's a few things that I want to mention. I'd like to refer back to last week's coffee break briefing, which was an espresso coffee break briefing, one that we slotted in out of the normal schedule. And that was to deal with the High Court decision in the Novalpina case, where there was a new ruling about the circumstances in which you should be converting a member's voluntary liquidation into a creditor's voluntary liquidation. The recording for that is now up on the website, so if you would like to see it again, if you missed it, there's the opportunity to do that. And I will apologise for the poor quality of the audio last week. We have got a new microphone installed this week, so I hope you'll be hearing me loud and clear today. And we've also made a transcript of something that's fairly close to what I said last week, so you can download that if you want to go and have a look at last week's recording as well. I'll be following up on that topic at the next coffee break briefing, which is on Monday, the 8th of September, when I'll be talking about the Section 95 procedure, so as to look at the method by which you convert from an MVL into a CVL and some of the issues that you might face if you're having to do that. And I'm also going to be speaking at the CESCA conference in Reading later that week. That's on Thursday, the 11th of September. And my topic there is evaluation experiences. So I'll be looking at the role of an evaluator in a Phoenix pre-pack in an administration and drawing upon some of my own experiences as an evaluator to inform that particular discussion. You can book that on the CESCA website, of course, if you haven't already done so, and I hope to see many of you there. Right, I think that's enough of the parish notices. Let's start the presentation itself. There are really just three topics we're going to cover today. First of all, we're going to look at what the Redundancy Payments Service said in their recent post in Dear Insolvency Practitioner 168, which was the trigger for bringing this in as a session in this series of presentations. We'll be looking at what that actually means in terms of Chris giving an employment lawyer's perspective on how to read the guidance from the RPS. And we'll be following that with some ideas of things that you should be thinking about to add to your compliance checklist for when you're filling in the forms for submission to the RPS. So let's start by looking at what the RPS actually said in Dear IP number 168. It's a fairly short post. There were just 6 paragraphs in it, and I'll take you through those one at a time. So the first one was really just a grumble that the RPS seemed to be unhappy with having to reject claims on the basis that the person making the claim is not eligible because they're not an employee. And this may or may not be connected to organisations that I've seen advertising their services, helping directors to make a claim themselves when their company goes into liquidation, make a claim on the basis that they think they are an employee. And there's a reference there to the Employment Rights Act 1996, which is a useful reminder that there is law outside the Insolvency Act that insolvency practitioners need to be aware of, and which I'm sure that Chris will be referring to in a little more detail later. The next paragraph is a general point of principle, saying it's your job as an insolvency practitioner to complete forms RP 14 and 14A to give the RPS the information that they need about the company, its insolvency, and the employees who may be making claims against them. And they say that it is your job for validating the information that claimants provide in the submissions you make in those forms. And they go on to say that therefore have the job not to actually confirm that the information is accurate, but you have to have appropriate safeguards in place. There are things that you have to do to check that the information you're giving to the RPS is accurate and valid. And they then move on to give some examples of that. So they're saying you should think about all available means of finding the relevant information, with a particular emphasis on getting hold of employment contracts, including sample contracts, and reviewing them. And as part of that review, they're saying you should be analysing whether it is genuinely an employment contract or not. And they draw a couple of distinctions here that they think you should be looking at. Firstly, the difference between a contract for service as opposed to a contract of service, and then the distinction between workers who are employees and workers who are not employees, on the basis that a worker who is not an employee will not have a contract of service and therefore should not be included in the information that you give to the RPS on forms RP14 and 14A. And then they finish off by saying that if the information is incomplete, or if you think that you cannot be sure that it's accurate, you then have to decide how much of that information you pass on to the RPS, with the final sentence being one that I read as saying that if you decide that you don't think the claim is a good one, the RPS are likely to follow your lead in that and are likely to refuse to pay out. So that's the publication that got us here. That's what Dear IP168 said. And what I'll do now is hand over to Chris and ask you, Chris, if you can try and explain what does all of that mean, please.
Thank you, Malcolm. No pressure at all, but I'll try my best. Yes, as Malcolm's just indicated, what we thought would be useful here is to go almost back over exactly what he's just presented on, but with my input through an employment lens. What I will say before we start going through that is I do have a couple of slight concerns, and Malcolm's indicated them there with reference to the focus in 168 there on the contract, which I think is potentially a little, and I'm sure unintentionally, misleading. And of course, as Malcolm said right at the start, it's quite a short note as these go. It doesn't really say a huge amount, but there is some content in there that I think we do need to unpick. So, Malcolm, if we could have the first paragraph up, please. And I appreciate this will probably be traumatising people from COVID days if I say next slide, please. So this, in my view, as a statement, is absolutely true. Only full employees, as opposed to workers, and we'll come back to that distinction, have unfair dismissal rights and can bring redundancy claims. So it makes sense that under Part 12 of the Employment Rights Act, and since Malcolm mentioned it earlier and it's there on the slide, sections approximately 180 to 190, for those of you who do want to sit and read some employment legislation, that does make it clear that only employees can therefore make an associated claim to the RPS. Anybody else would be making a claim to which they are not entitled. The definition of an employee is given to us in section 230, as it says there in the notes. And what section 230 tells us is that an employee is an individual who has entered into or works under, or perhaps for our purposes now where the employment has ceased, worked under, a contract of employment. Helpfully there, an employee, somebody who has an employment contract. Contract of employment is also defined in the legislation, and that draws us back to, or I suppose forwards to, a point I'll come on to. An employment contract is a contract of service. So if we can go to the next slide, and maybe just as I'm talking, move between them, please, Malcolm. We know the obligation ultimately is to if we jump to slide there, Malcolm, I know we've got our RP14 mentioned in there, I do apologise. Ultimately, to complete these forms, as Malcolm was saying, 14 and 14A. Now, I appreciate I'm probably talking to people who are used to filling them out quite regularly. I'm not going to go through the information that is in those. What is useful to bear in mind here is that the kind of information that you're looking at, particularly for the 14A, and which is filled in that associated sheet, is actually information that I'm going to suggest in due course is quite useful to ensuring that we're complying with 168 anyway. What I will say is, to the best of my knowledge, neither of these forms is drastically changing. There doesn't appear to be any indication of that. And as Malcolm indicated when he was going through the basic provisions of this 168 notes, it is important to remember that this is about validation of that information and ensuring that it's coming from a source which you feel reasonably confident in. So if we could just jump forward, I think we've got a brief mention of what's in the Form 14, which I will not comment on in the slightest. I've unfortunately not had to fill one of those out. And the 14A, as I said, does give us information about each employee. Various forms of that I have seen, but it does tend to be in quite a lot of information, and things like hours, salary, years of employment are all often included in there. So that brings us back, if we can go to the next slide, to this question about office holder responsibility. First thing to point out here, that idea of office holder is defined in the legislation. So again, it's in Part 12, it's in Section 187. It includes trustees in bankruptcy, liquidators, administrators, receivers, trustees under an arrangement between an employer and its creditors or their creditors, and trustees under a deed for creditors. I think the intention there, of course, to encapsulate any situation where somebody who could be deemed to be an employer, whether that's a commercial entity or an individual, who is in broadly an insolvency situation, is caught by the relevant definition here. The responsibility wording here is oddly slightly different to how it is in the legislation, but you can see it's almost a mirror image. What it says in the legislation is that a payment to employees on insolvency cannot be made without a relevant statement by a relevant officer as to the amount of that debt. And again, that echoes what Malcolm was indicating himself earlier when we were looking at this section. That is ultimately coming down to the insolvency practitioner, the person completing that form, to validate from a series of sources that information. If what you're saying matches what the employee puts on their own claim to the RPS, it's almost certainly going to be ticked off, so to speak. The RPS, like many government organisations, are not keen on spending a huge amount of time and resources on a long series of individual investigations or audits into the information they receive. Therefore, that should therefore take steps phrase in there is, I think, very clearly a message to you that in completing these forms, you are making a statement that the RPS intends to rely on. In effect, it's a statement to the Secretary of State via the RPS that the payment to that individual can and should be made. Whether that's right or not legally, very different question, but that is apparently what 168 is saying. And as we've both indicated, if those two bits of information marry up, the payment will be made. I think interestingly, also under Part 12, which for those of you who haven't read it, this may come as a slight surprise, we have Section 190 in there. Section 190 actually creates a criminal offence of refusal or being willfully negligent in providing any required information, which the SOS, Secretary of State, therefore via the RPS, may request in order to make their own determination. Now, I don't think this is necessarily a statement to the effect that if you accidentally provide the wrong information, we're going to convict you, but the logical extension of making and highlighting this reference, I think, here, is that if the RPS did decide to audit that decision-making in respect of an employment claim by an individual or a series of individuals, and any information had not been properly collated, someone somewhere is potentially criminally liable. Now, of course, that may well be that that's a useful stick for you to get that information in the first place, rather than one that you need to fear yourselves. But I think definitely worth highlighting that potential criminal offence is in there. So if we could move to the next slide, please, Malcolm. I don't think this is necessarily a particularly onerous obligation per se. The vast majority of staff in the vast majority of businesses are employees. They will be working regular hours under a genuine employment contract, receiving salaries via PAYE in the usual way. And so generally, the kind of information that you'd be looking at anyway, particularly that information for 14A, is going to be useful regardless. I think my main area of concern with this element of 168 and the subsequent paragraph, and we can jump there now, is this somewhat excessive focus on the employment contract itself. So one thing that I do just want to point out here, the wording of a contract is not determinative of employment status, and that is true both in the employment rights jurisdiction through the tribunal and indeed the tax jurisdiction. Those of you who have dealt with IR35 issues and employment status there will know that the employment tribunal and the courts are more than capable of looking beyond a contract and making a determination based on what actually happens on the ground. So I think the next paragraph and the next slide brought us back to that quote of contract for versus contract of service. I think quite importantly here, I've not seen an employment contract for a long time that uses either of these phrases. And that's partly because we're actively encouraged to write contracts in plain English to ensure the workers understand them. And so if you cast your mind back to when I was talking about the definition of employee and that slightly convoluted route of ending up an employee operates under a contract of service, then again, legally speaking, this paragraph is absolutely correct. The problem I think it produces is, firstly, the contract will not use that phrase, and two, even if it does, that doesn't guarantee the person is an employee, simply because of this court fixation on practical arrangements rather than contractual documents. So Malcolm alluded to one of the two possible reasons for this, what I'll call crackdown, and that starts with directors who have never actually been employees suddenly deciding it may suit them to be able to bring a redundancy claim after 20 years of only doing half an hour's work a month or whatever the case may be. And that one should be a red flag anyway, people who are on sort of the £12,500 salary and take more of their remuneration from dividends. And I think the other area to raise a slight flag here is people who are deemed workers more collectively, and also potentially that grey area between when they're workers and when they're self-employed. And I think the important thing to bear in mind here, all employees are workers, not all workers are employees. Useful Venn diagram, as I know Malcolm enjoys including where he can. The dividing line is actually quite a grey area. It's one employment lawyers and indeed judges routinely get wrong. There is a reason that the Uber drivers case ended up in the Supreme Court, and it's because employment law hadn't caught up with the gig economy and that kind of working relationship at the time. The distinction between a worker and an employee is ultimately this test of the degree of control, the extent to which the engaging entity has control over the means, mode and method by which the individual works. Most of us who are employees will be used to giving up a significant amount of control to our employers. We're told what hours we work, what jobs to do, what to take on, how to do it, when we can have our lunch breaks, when we can have holidays, all of those sorts of things. What then waters that down to worker status is the lesser control there, and it's usually the ability to take a shift or take a piece of work or not. So, prime example of why the RPS may be concerned about this. Uber was a good example. We could also use someone like Deliveroo. If they suddenly went under in the next month and all of their probably workers decided they were employees because it suited, I don't think the RPS is going to be thrilled about potentially having to pay a significant amount in that situation out of what is ultimately taxpayer funds. But ultimately, I suspect in both cases, this is about the RPS not wanting to make those payments to people who have not taken on the more onerous side of being an employee for their employment life cycle and are deciding now that it potentially suits them now that the relationship has ended and somebody else may be paying them. And I think that brings us to the final paragraph of 168, and it's probably worth mentioning here, yes, strictly speaking, it's true that this is an employee putting forward the application, putting forward their claim for a payment. But as we've both indicated today, that application is likely to be approved or rejected based on whether the information they provide marries up with the information that has been provided on Forms 14 and 14A. And I think that's where the indication is coming that there is responsibility on the IP here to ensure that that information is correct insofar as it can be reasonably validated. It's obviously also worth pointing out that if the employee believes they have been wrongly assessed, their cause of action is through the employment tribunal. They do have time to do that after the determination. And so maybe just to summarise those points very quickly for a moment, I think the takeaway, and I will sound like a broken record here, as much as 168 seems to suggest it could be, the contract is not going to be determinative in making this status between a worker and an employee clear. And that brings us on to the kind of things that perhaps I would look at if I were being asked to make a determination. I think for legal purposes, or if it was an individual claimant coming to me saying I want to be an employee, my obligation is to them individually. I think what I'd be doing is significantly more onerous. I'd probably be exploring their actual working relationship. But what we thought would be helpful is to give you some of the data, some of the information that's likely to be available from the company and how that can be useful to you in making these kind of tests. So the first slide, I believe, ironically, starts talking about the contracts again. And as much as I've just said they're not determinative, they are useful. As a matter of basic contract law, the document that is produced at the time does at least show the intent of the parties at the time they entered into it, and that can be helpful. A well-drafted contract will be able to show a distinction between a worker and an employee. It's unlikely to use those phrases contract of or contract for service, but with any luck, you will get a line in there that says something like, this is a contract of employment for the purposes of the Employment Rights Act, or this is not, with an explanation as to why. 168 talks about looking at sample contracts. Yes, I think where you've got a large organisation with a significant number of employees or workers, I think it's proportionate to use samples or templates rather than to check every single individual one. Obviously somebody else will, and certainly payroll when we get there, will be able to collate a lot of the data that should be in there anyway. But I think bear in mind two situations where more detail may be required, and that's one, smaller entities who are more likely to have variation, older contracts that are produced ad hoc as and when required, but also contracts that are produced for particular individuals in particular roles, because again, what they're doing on the ground may be very, very different from what it actually says in their contract. The next slide and next source of useful information, I mentioned payroll. Again, not absolutely determinative, in the same way that somebody being paid off payroll doesn't necessarily mean they're self-employed for IR35 purposes. It's also true in the employment rights jurisdiction. That said, somebody who has been working for a long time on a regular salary, receiving an annual salary divided down into 12 equal amounts via PAYE, it's all starting to look much more like an employee. Again, this goes to that element of degree of control. If it's likely to be one of their sole forms of income, if it's a figure that they are relying on, if it's fixed by the contract, that's all much more determinative of employee status than it is of somebody who's charging by the hour or by project piece. And then the next slide, please, I think brings us on to working hours, which I'll just skim over very briefly because I've touched on it already. Somebody working a regular work pattern, it looks more like they're being told when to work. Again, it comes back to this degree of control, particularly somebody working full-time hours. Again, we know that's not determinative. You can be self-employed and do a 40, 48-hour week, whatever the case may be. But equally, somebody who is working inconsistent working hours only appears to take on shifts when they're needed, or vice versa, doesn't take on shifts just because they don't fancy it, much more likely to be a worker than an employee. And then I think the last one refers to additional benefits, which again forms part of this remuneration idea. It will require looking at the contract, of course. It's also information available from payroll, but employees are more likely to be rewarded for that loyalty and for that surrender of their control about how they work by being given additional benefits. So again, not determinative. You may well find that people at higher levels who may not be employees are given some of these first. But additional holiday pay, enhancements on statutory family-friendly rates, all indicate that this is an employer recognising loyalty in an employee, usually for long service, and rewarding accordingly. So I think in general summary, like I said, broken record, the contract is useful, it's not determinative. But I think what's probably being driven at here is be aware that this situation is arising, that there are claims going forward which are maybe not legitimate, which the RPS should not be paying out and not processing. And this does feel like a little bit of a warning, just to be careful perhaps that we're not, I won't use the word facilitating to that extent, but that we're not allowing these to slip through the net where possible. Malcolm.
Thank you very much, Chris. I see we've actually got some questions have come in. I don't know whether you're able to see them on your screen, Chris.
No, I can't, unfortunately, so I'll leave them to you.
Okay, it's one question in three parts.
Okay.
And the thing about insolvency practitioners, their questions are very rarely hypothetical. And this one starts with the phrase, "I have a case." Employer was a recruitment agency.
Yes.
The agency workers, temporary staff, were employed under a contract for services, and the RPS therefore refused to pay them arrears of wages. And then how does this deal with agency workers' rights to be treated the same as an employee after 12 weeks?
Yeah, very, very good question. Agency workers are ultimately workers, and as a general rule, fall outside the scope of Part 12. It actually depends specifically on the exact working relationship and which one we're talking about. If we're talking about the employer who is using agency workers, then on just that information, it sounds as though there's actually a chance that's the right outcome. The purpose of the equality between agency and non-agency workers is more akin to a discrimination claim in terms of treatment within the workplace than it is about statutory rights. If we're talking about employees of the agency itself, that's potentially a very different question because they're much more likely to actually be the agency's employees. I probably can't go into much more detail without knowing the specifics, but at a real basic level, agency workers are generally excluded from this, and the agency worker regs don't help them.
We have one more question has just come in. This says, if an employee receives wages below the minimum wage, i.e. less than 12,000 per annum on full-time hours, if you've got an employee who's being paid below that, is that an automatic rejection of their claim?
Not necessarily, because they would also, in theory, have a claim for non-payment of those wages. If we can demonstrate they have been working full hours and they're earning below national minimum wage, in theory, they can pursue that as a separate dispute. How successful that would be is a different question. It would almost certainly require a tribunal determination first. But no, to the best of my knowledge, there's not an automatic cut-off point for sort of value of the claim that the RPS use.
Chris, thank you very much. I think that has dealt with all questions now. So just to say thank you very much for your huge contribution to today's topic, which I certainly wouldn't be able to deal with on my own. Thank you very much, and thank you to all who've joined us to hear this, and I hope to see many of you again next month for the Section 95 presentation and perhaps also at the SESCA annual conference. So I'll just say now goodbye, and we shall sign off. Goodbye.